I'd like to welcome you to this public meeting of the New York City Rent Guidelines Board. This is just one meeting in a series of public meetings and hearings to determine the renewal lease adjustments for rent-stabilized housing units in New York City with leases commencing on or being renewed on or after October 1, 2019 and on or before September 30th, 2020. I will now take roll call. Please respond if present. Shayla Garcia.
Present.
Leah Godridge.
Present.
Cecilia Hossa.
Present.
Alex Schwartz.
Present.
Urman Tejeda.
Present.
Scott Walsh.
Present.
May you.
Present.
David Reese present. Let the record show we have a quorum.
You didn't call Patty.
Oh, Patty Stone.
Present.
Thank you. Sorry, Patty.
That's okay.
The proposed rental adjustments voted on at this meeting will be published in the city record and posted on our website, nyc.gov/RGB. 4 public hearings to comment on the proposed guidelines will be held on the following dates, times, and locations. Tuesday, June 11th, 2019, in the main theater of Hostos Community College in CUNY 450 Grand Concourse. That's from 5 to 8 p.m. Thursday, June 13th, 2019, at St. Francis College in downtown Brooklyn, 180 Remsen Street, also from 5 to 8 p.m. Tuesday, June 18th, 2019, Jamaica Performing Arts Center in the auditorium, 153-10 Jamaica Avenue in Jamaica, New York, 5:30 to 8:30 p.m. And Thursday, June 20th, 2019, Oberia D. Dempsey Multi-Service Center Auditorium at 127 West 127th Street, New York, New York, from 5 to 8 p.m. Directions to those hearings are posted on our website, nyc.gov/RGB. Pre-registration to speak at these hearings will begin tomorrow at 9 a.m. You can sign up by calling the Rent Guidelines Board offices at 212-669-7480, then press 0 to register. For further information, see our website. And as always, there are copies of our meeting schedule here tonight. The next board meeting will be held on May 16th in the Landmarks Preservation Commission Conference Room, David N. Dinkins Municipal Building, 1 Center Street, 9th floor, New York, New York, starting at 9:30 a.m. The final vote will take place on June 25th, starting at 7 p.m. It will be held here again at the Great Hall. Prior to taking any proposals from the board members, I will first read into the record the proposed language for apartment and loft order number 51 and hotel order number 49. New York City Rent Guidelines Board proposed 2019 apartment and loft order number 51. Proposed order number 51, apartments and lofts, rent levels for leases commencing October 1, 2019 through September 30, 2020. Notice is hereby given pursuant to the authority vested in the New York City Rent Guidelines Board by the Rent Stabilization Law of 1969 as amended and the Emergency Tenant Protection Act of 1974 as amended and as implemented by Resolution number 276 of 1974 of the New York City Council and in accordance with the requirements of Section 1043 of the New York City Charter, that the Rent Guidelines Board hereby proposes the following levels of fair rent increases over lawful rents charged and paid on September 30th, 2019. These rent adjustments will apply to rent-stabilized apartments with leases commencing on or after October 1, 2019 and through September 30th, 2020. Rent guidelines for loft units subject to Section 286, Subdivision 7 of the Multiple Dwellings Law are also included in this order. Proposed adjustment for renewal leases, apartments. Together with such further adjustments as may be authorized by law, the annual adjustment for renewal leases for apartments shall be, for a 1-year renewal lease commencing on or after October 1, 2019 and on or before September 30th, 2020, blank. For a 2-year renewal lease commencing on or after October 1, 2019 and on or before September 30th, 2020, blank. These adjustments shall also apply to dwelling units in a structure subject to the partial tax exemption program under Section 421A of the Real Property Tax Law or in a structure subject to Section 423 of the Real Property Tax Law as a redevelopment project. Proposed vacancy allowance for apartments. There shall be blank vacancy allowance. Proposed additional adjustments for rent-stabilized apartments sublet under Section 2525.6 of the Rent Stabilization Code. In the event of a sublease Governed by subdivision E of section 2526.6 of the Rent Stabilization Code, the allowance authorized by such subdivision shall be blank. Proposed adjustments for lofts, units in the category of buildings covered by Article 7C of the Multiple Dwelling Law. The Rent Guidelines Board proposes the following level of rent increase after the base rent as defined in Section 286, Subdivision 4 of the Multiple Dwelling Law for units to which these guidelines are applicable in accordance with Article 7C of the Multiple Dwelling Law. For one-year increase periods commencing on or after October 1, 2019, and on or before September 30th, 2020, blank. For two-year increase periods commencing on or after October 1, 2019, and on or before September 30th, 2020, blank. Vacant loft units proposal. There shall be blank vacancy allowance. Fractional terms proposal. For the purposes of these guidelines, any lease or tenancy for a period up to and including 1 year shall be deemed a one-year lease or tenancy, and any lease or tenancy for a period of over 1 year and up to and including 2 years shall be deemed a two-year lease or tenancy. Escalator clauses proposal. Where a lease for a dwelling unit in effect on May 31, 1968, or a lease in effect on June 30th, 1974, for a dwelling unit which became subject to the Rent Stabilization Law of 1969, by virtue of the Emergency Tenant Protection Act of 1974 and Resolution Number 276 of the New York City Council, contained an escalator clause for the increased costs of operation, and such clause is still in effect. The lawful rent on September 30, 2019, over which the fair rent under this order is computed, shall include the increased rental, if any, due under such clause, except those charges which accrued within 1 year of the commencement of the renewal lease. Moreover, where a lease contains an escalator clause that the owner may validly renew under the code, unless the owner elects or has elected in writing to delete such a clause, effective no later than October 1, 2019, from the existing lease and all subsequent leases for such dwelling unit, the increased rental, if any, due under such escalator clause shall be offset against the amount of increase authorized under this order. Special adjustments under prior orders proposal. All rent adjustments lawfully implemented and maintained under previous apartment orders and included in the base rent in effect on September 30, 2019 shall continue to be included in the base rent for the purpose of computing subsequent rents adjusted pursuant to this order. Proposed special guideline. Under Section 26-513B1 of the New York City Administrative Code and Section 9E of the Emergency Tenant Protection Act of 1974, the Rent Guidelines Board is obligated to promulgate special guidelines to aid the State Division of Housing and Community Renewal in its determination of initial legal regulated rents for housing accommodations previously subject to the city rent and rehabilitation law, which are the subject of a tenant application for adjustment. The Rent Guidelines Board hereby proposes the following special guidelines. For dwelling units subject to the rent and rehabilitation law on September 30, 2019, which become vacant after September 30, 2019, the special guideline shall be blank. Decontrolled units proposal. The permissible increase for decontrolled units as referenced in Order 3A, which became decontrolled after September 30th, 2019, shall be blank. Credits proposal. Rentals charged and paid in excess of the levels of rent increase established by this order shall be fully credited against the next month's rent. Statement of basis and purpose. The Rent Guidelines Board is authorized to promulgate rent guidelines governing apartment units subject to the Rent Stabilization Law of 1969 as amended and the Emergency Tenant Protection Act of 1974 as amended. The purpose of these guidelines is to implement the public policy set forth in findings and declaration of emergency of the Rent Stabilization Law of 1969, Section 26-501 of the New York City Administrative Code, and in the legislative findings contained in the Emergency Tenant Protection Act of 1974, Law 1974, Chapter 576, Section 4, Subsection 2. The Rent Guidelines Board is also authorized to promulgate rent guidelines for loft units subject to Section 286, Subdivision 7 of the Multiple Dwelling Law. The purpose of the loft guidelines is to implement the public policy set forth in the legislative findings of Article 7C of the Multiple Dwelling Law, Section 280. And these orders shall be dated May 7th, 2019, and ultimately signed by me as Chair, David Reese, New York City Rent Guidelines Board. That was a mouthful. Unfortunately for us all, there's another mouthful as I have to read into the record the hotel order, so please bear with me. New York City Rent Guidelines Board proposed 2019 Hotel Order number 49. Proposed Order number 49. hotels, rooming houses, single-room occupancy buildings, and lodging houses. Rent levels to be effective for leases commencing October 1, 2019 through September 30th, 2020. Notice is hereby given pursuant to the authority vested in the New York City Rent Guidelines Board by the Rent Stabilization Law of 1969 as amended, and the Emergency Tenant Protection Act of 1974 as amended, and the Emergency Tenant Protection Act of 1974 as amended and is implemented by Resolution Number 276 of 1974 of the New York City Council, and in accordance with the requirements of Section 1043 of the New York City Charter, that the Rent Guidelines Board hereby proposes the following levels of fair rent increases over lawful rents charged and paid on September 30th, 2019. Applicability. This order shall apply to units and buildings subject to the hotel section of the Rent Stabilization Law, Sections 26-504C and 26-506 of the New York City Administrative Code as amended, or the Emergency Tenant Protection Act of 1974, Law 1974, Chapter 576, Section 4, Subsection 5A7. With respect to any tenant who has no lease or rental agreement, the level of rent increases established herein shall be effective as of 1 year from the date of the tenant's commencing occupancy, or as of 1 year from the date of the last rent adjustment charged to the tenant, or as of October 1, 2019, whichever is later. This anniversary date will also serve as the effective date for all subsequent Rent Guideline Board hotel orders, unless the board shall specifically provide otherwise in the order. Where a lease or rental agreement is in effect, this order shall govern the rent increase applicable on or after October 1, 2019, upon expiration of such lease or rental agreement, but in no event prior to 1 year from the commencement date of the expiring lease, unless the parties have contracted to be bound by the effective date of this order. Proposed rental guidelines for hotels, rooming houses, single-room occupancy buildings, and lodging houses. Pursuant to its mandate to promulgate rent adjustments for hotel units subject to the Rent Stabilization Law of 1969 as amended, Section 26-510E of the New York City Administrative Code, the Rent Guidelines Board hereby proposes the following rent adjustments. The allowable level of rent adjustment over the lawful rent actually charged and paid on September 30th, 2019 shall be 1. Residential Class A apartments, hotels, blank. 2. Lodging houses, blank. 3. Rooming houses, Class B buildings containing less than 30 units, blank. 4. Class B hotels, blank. 5. Single-room occupancy buildings, multiple dwelling law, Section 248, SROs, blank. New tenancies proposal. Blank vacancy allowance is permitted under this order. Additional charges proposal. It is expressly understood that the rents collectible under the terms of this order are intended to compensate in full for all services provided without extra charge on the statutory date for the particular hotel dwelling or at the commencement of the tenancy if subsequent thereto. No additional charges may be made to a tenant for such services, however such charges may be called or identified. Statement of basis and purpose. The Rent Guidelines Board is authorized to promulgate rent guidelines governing hotel units subject to the Rent Stabilization Law of 1969 as amended and the Emergency Tenant Protection Act of 1974 as amended. The purpose of these guidelines is to implement the public policy set forth in Findings and Declaration of Emergency of the Rent Stabilization Law of 1969, Section 26-501 of the New York City Administrative Code, and in the legislative findings contained in the Emergency Tenant Protection Act of 1974, Law 1974, Chapter 576, Section 4, Subsection 2, and to be dated May 7, 2019, to be signed by me, David Reese, Chair, New York City Rent Guidelines Board. Okay, all right, so that's out of the way.
We're like falling asleep.
Each year, we vary from having owners and tenant representatives on the board make the first motion. Last year, tenants made the first motion, so this year we will look to owners to make the first motion. The proposed rent stabilized hotel guidelines, so rent adjustments for residential Class A hotels, lodging houses, rooming houses, residential Class B hotels, single-room occupancy buildings.
Good evening. My name is Patty Stone, and I am one of the two owners' representatives on the Rent Guidelines Board, along with Scott Walsh. I am cognizant of the fact that New York City has become unaffordable for some and expensive for many. However, that burden belongs on the doorsteps of the mayor's and governor's offices and not on the shoulders of the owners of rent-regulated housing. Owners are people who invest their hard-earned money in a building to run as a business to support their families. We live in a capitalist society where people go into business to earn a profit, not just to break even. The facts we have been provided with clearly establish that owners are entitled to an increase in guidelines. These facts include, since 2014, Since 2014, property taxes have increased 38%, over 7% per year. Between 2014 and 2018, water rates have increased 8.7%. Since Mayor de Blasio has taken office, the price index of operating costs has increased 3.5%, while one-year guidelines have increased only 0.75%. Since 2002, one-year rent guidelines have averaged 2.5%, while the price index of costs have averaged 5.1%. Between 2014 and 2019, the price index of operating costs has increased 21.2%, while one-year rent guidelines have only increased 3.7%. Union wages increase each year, as have the minimum wages. Okay? The mayor keeps issuing new local laws which increase owners' costs, such as the new allergen law and greenhouse gas emissions. I am not commenting on these laws, but it is indisputable that these new laws result in increased costs for owners. The net operating income The net operating income is the amount an owner earns after all the expenses are paid. The last 3 years have shown diminishing increases in net operating income. Simply put, the facts establish that owners are being undercompensated. The cost The costs of running a building keep increasing while the money coming in is not increasing at the same pace as the cost. The mayor cannot advocate for big government and unlimited tax increases and simultaneously manipulate the outcomes of the board with a very heavy hand. There are 2 owners' representatives, 2 tenant representatives, and 5 public members on this board. It seems obvious that the owner's representatives would lean toward the owner's side and the tenant's representatives would lean toward the tenant's side. However, the public members are supposed to be unbiased and fair and make their decisions based solely on the evidence. The evidence consists of the testimony we've heard and the studies we were provided with, which overwhelmingly establish that owners are entitled to a minimum increase of 3.75%. An important point to note is that there are approximately 72,000 units who receive scree or dree and another 67,000 who receive Section 8, all of whom are protected from any rent increase issued by this board. At this point, I would like to put forward a motion for proposed rental adjustments for rent-stabilized apartments and lofts. Hotel first. I'm sorry, we're gonna do hotels first. At this point, I would like to put forward a motion for opposed rental adjustments for rent-stabilized hotel units. I move to adopt the language of the proposed hotel order number 49 as read into the record at this meeting, and I move to adopt the following proposed rental adjustments for rent-stabilized hotels. Residential Class A hotels, 3%. Lodging houses, 3%.
3%.
Rooming houses, 3%. Class B hotels, 3%. Single-room occupancy buildings, 3%. I propose a vacancy allowance of 10%. To summarize, in accordance with my motion, you are voting on the adjustments I proposed and the proposed language of the order.
Is it 3% across the
Yes.
board? Yeah.
That's it. Is there a second for the motion?
Second.
So let me restate the motion before we open it for discussion. So to restate the motion, it's a 3% increase for all categories of hotels and a vacancy allowance of 10% for all categories of hotels. Do I hear any discussion on the motion? Any discussion on the motion? Okay. Hearing no discussion on the motion, I call the question. Shayla Garcia.
No.
No. Leah Goodridge.
No.
Cecilia Hossa.
No.
Alex Schwartz.
No.
Patty Stone.
Yes.
Herman Tejeda.
No.
Scott Walsh.
Yes.
Nay Yu.
No.
David Reese, no. The motion fails. 2 pro, 7 con, 0 abstentions. Do I hear a motion? Do I hear a motion from the tenant members?
Yes. At this time, I would like to put forward a motion for proposed rental adjustments for rent-stabilized hotel units. I move to adopt language as of proposed hotel order number 49 as read into the record at this this meeting. I move forward to adopt the following proposed rental adjustments. Before I read the rental adjustments, I just want to say that rent-stabilized hotels house the most marginalized people in our city, lowest income. They're actually also paying a huge amount of their fixed income, many. And so these are the marginalized people of our city, the people who are sharing bathrooms, who live under conditions that many of the tenants who live in rent-stabilized units would deem uninhabitable. And I think that we have done right as a board for all hotel tenants for many years. We have lost many of the hotel tenants, the actual rent-stabilized units, and I think that in this moment, we are in a moment to make sure that we don't do the same to rent-stabilized housing. And so we are protecting rent-stabilized hotels when we do this. I would also like to highlight a few comments made earlier. Our board is not making sure landlords continue to make profit. Our board is mandated to actually make sure that we simulate a fair housing market, which we do not have in New York City. For that very reason, and for protecting all of the marginalized people that live in rent-control hotel apartment units, I am proposing a residential Class 8 hotel adjustment of 0. Lodging houses, 0. Rooming houses, 0. Class B hotels, 0. Single room occupancy building, 0. No vacancy allowance will be allowed. To summarize, in accordance with the motion, you are voting on adjustments I just proposed and the language in the order.
Do I hear a second for the motion?
Yes, second.
I'm sorry, Shayla, can I just clarify? Are we going to keep the language that's in the order of no vacancy allowance? Is that
Yes.
acceptable? Yes, thank you. Do I hear a second for the
Second,
motion?
yes.
Okay, so let me restate the motion. So for all classes of hotels, the motion calls for a 0% increase and no vacancy allowance. Any discussion on the motion? Any discussion on the motion? Hearing no discussion, I call the question, and I shall take votes. Shayla Garcia.
Yes.
Leah Goodridge.
Yes.
Cecilia Hosa.
No.
No? Alex Schwartz.
Yes.
Patty Stone.
No.
Herman Tejeda.
Yes.
Scott Walsh.
No.
May Yu.
No.
David Reese. Actually, David Reese, yes. I'm sorry. This is the zeros and vacancy. This is. You know, I'm gonna, as having voted for the motion, I'm gonna check in again. I think that some of the members were confused about their votes. Is everyone comfortable with the vote that they made, or does
For
anyone?
hotels.
This is for hotels.
I would like to vote yes.
Okay, so. Does anyone else want to change their vote? You're good? Everyone's good? Okay, very good. Okay, so let me see. I have 1, 2, 3, 4, 5, 6 yes. It passes. 1, 2, 3 no. Okay. Okay. So next on our agenda is the apartment order. And we, again, return to the owners.
Okay. At this point, I would like to put forward a motion. I'm sorry. At this point, I would like to put forward a motion for proposed rental adjustments for rent-stabilized apartments and lofts. I move to adopt the language of the proposed apartment and loft order number 51 as read into the record at this meeting, and I move to adopt the following proposed rental adjustments for rent-stabilized apartments and lofts. For a one-year renewal, a range of 3.75 a range of 3.75 to 5.75. For a two-year renewal, a range of 4.75 to 6.75. propose the same range of increases for lofts. I propose an increase for sublets of 10%. In the event, and only in the event, that the state abolishes the vacancy increase, I then propose that if there has not been a vacancy increase for the past 5 years, a 15% increase be granted. And if there has been a vacancy increase within the past 5 years, then I propose a 10% increase be granted. For the special guideline,
10% if there was a vacancy.
for the special guideline, I propose 150% above the MBR plus fuel. Which doesn't affect anybody in this room.
I didn't hear the last thing she just said.
I'm sorry?
I didn't hear the last thing she just said.
She's saying
To
that
summarize.
that wasn't true, that she's suggesting a 10% above something. I didn't hear the something.
To summarize, in accordance with my motion, you are voting on the adjustments I proposed and the proposed language of the order.
Patty, can you clarify the last statement that you made about the 150%? What is that special guideline?
sorry.
I didn't catch the 150%. Could you just repeat
For
that?
the special guideline, 150% above the MBR plus fuel.
Plus what?
Fuel.
Fuel, plus fuel. Okay, thank you. Do I hear a second for that motion?
Second.
Okay. Okay. So let me restate the motion. The motion is for a apartment 1-year range of 3.75% of to 5.75%, and the 2-year is 4.75% to 6.75%. A sublet allowance of 10%, lofts to have the same range as the apartments, and special guidelines if state were to abolish the vacancy increases, a 15% increase if no vacancy for more than the past 5 years, and if there has been an increase in the past 5 years, then 10%, and 150% above MDR plus fuel. Do I hear any discussion on the motion? Any discussion on the motion? Hearing none, I call the question. Shayla Garcia.
No.
Leah Goodridge.
Hey, hey, ho, ho, high rent has got to go. No.
Cecilia Hossa.
Now.
Alex Schwartz.
No.
Patty Stone.
Yes.
Armand Tejeda.
No.
Scott Walsh.
Yes.
May Yu.
No.
David Reese, no. The motion fails, 2 for, 7 against, 0 abstention. Do I hear a motion from the tenant representatives?
Yes.
Actually, I have a headache. They're giving me a headache.
So we are proposing a motion today. I'm one of the tenant reps, as all of you know, and we're proposing a motion today for a rent rollback. I can't really hear you. Okay. I think we're all in agreement on that. I want to talk a little bit about why we're proposing a rent rollback. It took me a while to get here. I work in Lower Manhattan, and as most of you know, I'm a tenant attorney at a nonprofit called Mobilization for Justice, and as I took the train here to Cooper Union, I saw a bunch of people. I saw teachers with their students online. I saw the train conductor. I saw maintenance workers. I saw firefighters. And I wondered about these people who help New York City run. And the one thing I wondered is New York City running for them? Now, if you go on Craigslist right now, and you can call it a game, try to find an apartment for less than $1,600, a one-bedroom, you'd be hard-pressed. And I know that that's difficult because I work with clients every day on trying to find an apartment to avoid getting evicted. And in a lot of these cases, I have to sit down with people who are in their 60s, some people who fought for this country, and tell them, you might want to think about getting a roommate. And when I tell people this, they often cry, and they say, I can't believe this. I've been living in this city since I was a child, and I'm being priced out. So right now, for example, the starting salary for a police officer is about $42,000. For a teacher, it's about $56,000. For an EMT, it's about $33,000. And by the time you take out taxes, how can you afford a two-bedroom apartment at, what, $2,500? What we're hearing today are increases on 10%, but people right now can barely afford to live in New York. This is a renter city. The fact of the matter is, this is a renter city. Most of the people who live here are renters. We were talking about a game before about trying to find an affordable apartment to rent, but try buying. That's very difficult as well. And so those are the reasons why we're proposing a rent rollback, because we are in full awareness that we are living in a housing crisis. It's a crisis when most of the city, most of the people who do the jobs for the city to help the city run cannot afford to live in the city. Most of the people, I grew up here, and most of the people that I grew up with have moved out, not because they don't like New York, but because apparently New York doesn't like them. New York is not affordable anymore. People have moved down south. And people have moved to other states because they cannot afford to live in this city. And for those reasons, and many more, we are proposing a rent rollback.
So before I get to the numbers, I actually wanted to give some numbers to the stories and the faces that Leo was trying to paint for us. There are over 60,000 people sleeping in homeless shelters every night. 100,000 people will go through the shelter this year alone. .43% of all evicted tenants are coming from rent-stabilized housing. So what does that actually tell us? It tells us we need more protections for tenants. It tells us that investments are doing okay. They are okay. We see buildings continuing to be flipped, bought over again, predatory landlords making profits over tenants consistently over and over again. 33% of tenants citywide are paying over 33% of their income in rent. That means that half of those tenants are paying double that amount, which is 66, and half are paying less, which means that they maybe have more affordable rents. What does that mean as a city when we have less than a 5% vacancy in the city? That we're in a crisis. That's why the rent stabilization law exists. After last year's adjustments of rent increases, a rent hike that I personally feel was unmerited, landlords have claimed that they can continue to have profit. Let me tell you, NOI has gone up for the 13th consecutive year in a row. So they're doing just fine. Yeah, the cost of a bucket maybe went up this year. That does not mean that they merit an increase. That does not mean we dig into the pockets of tenants to make sure landlords continue to feel like they're making a profit. For decades, landlords have been able to tap into MCIs, IAIs, vacancy bonuses, and a whole bunch of other fees that are not even regulated that landlords can charge people, like a third month's rent just for moving in. These fees have continued to put pressure on the most marginalized people in the city, has displaced and gentrified throughout the whole city of New York. We can't do this anymore. Tenants in the city are struggling, and we have to do the right thing by them. It is not our mandate to make sure that landlords continue to feel entitled to have rent increases. It is not our mandate. Where were landlords complaining about manipulation of the board when they were getting unprecedented increases year after year under Bloomberg? Now that the board is behaving in a way that maybe is more balanced because they're looking at both tenants and landlords' ability to pay, buy, and live in this city, now they cry. Our mandate is not to make sure landlords continue their profit. It is to simulate a fair market for both tenants and landlords like other cities have, because you can negotiate prices. This is why I'm asking for us to change the conversation from rent increases to rent adjustments. And that is why I'm calling for a negative 0.5 rent adjustment to 0 for a 1-year lease, a 0 to 1% for a 2-year leases. And I want to remind the board that we've been sued by landlords. When we had 0, the world was going to come crashing down. The data tells us that's not true. Tenants in the city are hurting, and the Supreme Court agreed that this board has the ability not only to look at the landlord side, but the tenant side also. And I urge every member of the board to do that. We are not responsible for continuing to have a current system that is unjust for tenants and make sure landlords continue to make a profit. We demand that this year, the public members stand with your values and vote for a negative 0.5 to 0 for 1-year lease, and a 0 to 1 for 2-year leases.
What do we want? When do we want it? What do we want? When do we?
At this time, I would like to put forward the motion for proposal rental adjustments for rent-stabilized apartments and lofts. I move to adopt language of the proposed apartments and lofts, order number 51, as read into the record at this meeting, and move to adopt the following proposed rental adjustments for rent-stabilized apartments and loft. 1-year leases, -0.5 to 0. 2-year leases, 0 to 1. No sublet allowance. Same for lofts. Do I have to repeat that? No, I don't. No vacancy allowance is permitted under this order, therefore, except otherwise provided by Section 286, Subdivision 6 of Multiple Dwelling Law. The rent charged to any tenant for the vacancy tenancy commencing on or after October 1st, 2019, and on or before September 30th, 2020, may not exceed the base rent, reference above, plus the legal adjustment permitted in the increase adjustments. So the special guideline would be 0, or the maximum base rent. To summarize, in accordance with the motion, you are voting on the adjustments I proposed and the proposed language of the order.
Clarify that the
Shayla, just to clarify, you discussed the no vacancy allowance, 0% or maximum base rent in the context of lofts. Is that the same language for in the context of apartments?
Yes.
Okay, thank you. Okay, do I hear a second on that motion?
Yes.
Okay, so let me summarize the motion. For apartments, a 1-year range of -0.5% to 0%. For 2-year leases, a 0% to 1%, no sublet allowance, and no vacancy allowance, which is 0% or maximum base rent. And for lofts, it's the same, but just to reiterate, -0.5% to 0% for 1-year leases, 0% to 1% for 2-year leases, and the same special guidelines, no vacancy allowance, 0% or maximum base rent, no sublet allowance.
confusing the special vacancy allowance.
All right, just to make sure that we have this on the record properly, the vacancy allowance is 0 for both apartments and for lofts under this motion. And it has been seconded. Any discussion on this motion? Hearing none, I call the question and we'll take votes. Shayla Garcia.
Yes.
Leah Goodridge.
Yes.
Cecilia Hossa.
No.
Alex Schwartz.
No.
Patty Stone.
No.
Armand Tejeda.
Yes.
Scott Walsh.
No.
May Yu.
No.
David Reese. No. The motion fails. It's 3 in favor, 6 against, no abstentions. At this time, I would like to put forward a motion for proposed rental adjustments for rent-stabilized apartments and lofts. I move to adopt the language of the proposed apartment and loft order number 51 as read into the record of this meeting, and I move to adopt the following proposed rental adjustments for rent-stabilized apartments and lofts. Apartments, 1-year lease, 0.5% to 2.75%. 2-year leases, Two-year leases, 1.5% to 3.75%. Sublet allowance of 10%. No vacancy allowance. No vacancy allowance is permitted except as provided by the Rent Regulation Reform Act of 1997 and the Rent Act of 2015. Lofts, 1-year leases, 0.5% to 2.75%. 2-year leases, 1.5% to 3.75%. Vacant loft units, no vacancy allowance is permitted under this order. Therefore, except as otherwise provided in Section 286, Subdivision 6 of the Multiple Dwelling Law, the rent charged to any tenant for a vacancy tenancy commencing on or after October 1, 2019 and on or before September 30th, 2020 may not exceed the base rent referenced above plus the level of adjustment permitted above for increased periods. Special guideline, 39% above the maximum base rent. To summarize, in accordance with my motion, you are voting on the adjustments I proposed and the proposed language of the order. Do I hear a second for my motion?
A second.
Hearing a second? To summarize, 1-year leases, 0.5% to 2.75%. 2-year leases, 1.5% to 3.75%. Sublet allowance of 10% and no vacancy allowance. And that applies. And that applies to lofts as well as apartments. Is there any discussion on the motion?
A second.
You want to say something? Okay, second. Yeah, okay. Okay, so hearing no discussion on the motion, I call the... I'm sorry.
What did you say?
Is there any discussion? Any discussion on the motion?
I think the only thing I will say is that we have seen data that has told me that range is way too high. I think last year we did an injustice doing another rent hike, and I think this motion should fail, and we should go back and actually have negotiations about a lower motion.
Any further discussion on the motion? Hearing none, I call the question and we'll take a vote. Shayla Garcia.
No.
Leah Goodridge.
No.
Cecilia Hossa.
Yes.
Alex Schwartz.
Yes.
Patty Stone.
No.
Herman Tejeda.
Yes.
Scott Walsh.
No.
May Yu.
Yes.
David Reese. Yes. The motion passes with a vote of 5-4. Do I hear a motion to adjourn?
Second the motion.
We are adjourned. Thank you.